Hi everyone and welcome to another episode. Today I want to talk about dispute resolution and more importantly to answer the question whether arbitration is better than going to court. Let's get started. Dispute resolution is one of the most important aspects of any legal system and the default is to go to court when a dispute arises. But as of late, the concept of alternate dispute resolution or ADR has become a point of discussion amongst many people. Now, first of all, we must understand that nothing can replace the court system of a country. And there are some disputes that can only be resolved by going to court. For example, criminal offences must be resolved by going to court. But there are some types of disputes that can be resolved using alternate dispute resolution methods. ADR usually includes three types of methods. Number one, conciliation. That is where an expert third party is appointed to convince the parties to enter into a settlement which is mutually acceptable. Number two is mediation. That is where the parties retain a third party to help and assist the parties to come to an amicable solution. And thirdly, arbitration. That is where one or more arbitrators are appointed to carry out a hearing between the parties and make a decision. Today I want to focus on arbitration because that's the most comparable to a court system and the one that gives a decision which is binding on the parties. And arbitration has gained a lot of popularity globally over the last few decades, especially when dealing with commercial transactions. One of the reasons why arbitration has become so popular when dealing with cross-border commercial transactions is because often there is confusion as to which country's court has the right to hear the case in the event of a dispute. And often there are complicated conflict of law rules that need to be applied to find this out. And further, even if a judgment can be obtained from one country's court, there is a question as to whether that can be enforced in another country. For example, if a Sri Lankan company provided tea to a company situated in England, and there was a question of payment, the Sri Lankan company might choose to bring an action in Sri Lanka, and the Sri Lankan courts might give a judgment. But since the British company is not situated in Sri Lanka and do not have any assets in Sri Lanka, the judgment would need to be enforced in England. And this could be complicated. To avoid this, the parties in the agreement may mutually agree that if a dispute were to arise, it will be resolved using arbitration at a mutually agreed upon location. When such an agreement is made, it excludes the possibility of the courts hearing the case and the matter must be referred to arbitration. Now the big question is arbitration better than going to court? Now there are some advantages of going to arbitration over litigation. One of the biggest advantages of arbitration is the ease of enforceability. Thanks to the New York Convention of 1958, to which most countries are signatories, an award made in one signatory country can be enforced in any of the other signatory countries without much hassle. So this makes enforcing an arbitration award much easier than enforcing a judgment. I'll link a list of the countries who are signatories to the New York Convention in the description below. Another advantage of arbitration is the fact that it's more expeditious than court proceedings. Provided the parties and the arbitrators agree, the arbitration can be concluded quite fast. This is aided by the fact that the procedure that needs to be adopted in an arbitration is quite flexible, provided the parties can agree. Another advantage of arbitration is that the parties can mutually agree on most aspects of the proceedings. This includes the procedural law, the substantive law, the time frames, the language, the place of arbitration, etc. Of course, this may vary depending on whether the parties have agreed to an ad hoc arbitration or an institutional arbitration. Where the parties have agreed to carry out the arbitration using an institution such as the SIAC or the LCIA, the parties will be bound by the rules of that institution and therefore may not be free to decide on all aspects of the arbitration. In addition, another advantage is that the parties are free to appoint any person as the arbitrator. So if the parties wanted to, they could appoint an expert in the subject area as the arbitrator, thus helping to expedite the process. Now, these are just a few of the major advantages of arbitration over going to court. Of course, there are disadvantages to choosing arbitration over litigation as well. One of the biggest downsides to choosing arbitration is that there is no option of appeal. Once you choose arbitration, you are bound by the award given by the arbitrator, unlike the courts where you are able to appeal a judgment given by a judge multiple times. Another problem with choosing arbitration is that it might be more costly than going to court, because you will have to bear costs related to the arbitrators, the venue, the arbitration center, in addition to the lawyer's fees. Whereas going to court, the cost that will be incurred will be far less. One of the other problems with arbitration is that you may have to consult the courts at various stages during the arbitration, especially during enforcement of the arbitration award. So the whole point of going to arbitration to avoid the courts would be lost. So clearly there are pros and cons in choosing arbitration over litigation. But most commercial entities today seem to have agreed that the pros outweigh the cons. Anyway, that's been it for this video. Let me know what you think is the biggest advantage of arbitration over litigation. And don't forget to like this video and subscribe to the channel if you enjoy this kind of content. I'll see you again in the next video. Take care.